Thank, thank you, Mr. Campbell, and sure, it is our pleasure to have your son to argue the case. Do we have the other party available? Madam Clerk, have we heard from the other party?
No, sir, not to my knowledge, we have not, sir.
Mr. Wolf, passed away, Judge McCleary, about 8 weeks ago, John Wolf.
Uh-huh.
And they were given a fixed amount of time by the Court of Appeals to obtain substitute counsel, and have not done so.
Okay.
And the argument was postponed. I think we were set in January, maybe weather postponed this.
Your Honor, would you like for me to check with the clerk's office to be sure?
Let's do that before we proceed, if we could.
Yes, sir.
Sir,
Excuse me, please.
make sure we've not heard from them. Mr. Campbell, we'll continue the tradition, huh?
Sure.
We're continuing the tradition where,
Yeah. Fourth generation, the way I count it, my grandfather and my father. My brother tries to suck in a great-grandfather on the other side, who was a Supreme Court justice.
They were not returned to us as undeliverable as addressed, so they were aware of the oral argument on today, but for whatever reason, they have not appeared.
In that case, if you so desire, you may present your argument, but otherwise, we will hear this case on briefs.
I'm sorry,
If you desire, you may present your argument, but otherwise, we'll hear this case on brief, as it is. On brief.
Yes, Your Honor, we'd like to present a brief argument.
If that's okay, go right ahead.
Thank you, Your Honor.
If this is your first time arguing in front of the Court of Appeals,
Yes, Your Honor.
it's not going to get any easier than this. You have no opposition.
Thank you, Your Honor. I appreciate that. May it please the court, good afternoon, Your Honors. My name is Hunter Campbell, attorney with Campbell & Campbell in Chattanooga, trying to keep the family firm going. We represent the defendant, appellee, Tennessee Farmers in this case. I'll try to briefly address the summary judgment in favor of Tennessee Farmers on plaintiff's claim for uninsured, underinsured motorist coverage. The grant of summary judgment should be affirmed, and the plaintiff should not be allowed to make an end run around the statutory and contractual limitations on recovery of UM, and should not be allowed to duplicate recovery of UM coverage. Defendant Oliver was at fault for this accident. The plaintiff settled their claim against Defendant Oliver, receiving payment of Oliver's liability coverage limits of $30,000 per person and $60,000 total. Then Tennessee Farmers had the coverage on the vehicle owned by its insured, Teague, a $50,000 per person limit in aggregate coverage of $100,000. Tennessee Farmers exercised its statutory right to defend under Tennessee Code Annotated 56-7-1206. Plaintiffs were personally insured by National Casualty under a policy providing $100,000 in UM coverage. National Casualty, for reasons unknown, not only waived its right to defend, but paid $50,000 per plaintiff to buy its piece. By statute, National Casualty was entitled to offset the liability coverage of $30,000 per plaintiff, such that it would have only been responsible for $20,000 per plaintiff. Plaintiffs received $80,000 each from Allstate and National Casualty, and then tried to proceed to recover additional UM coverage under the Teague policy with Tennessee Farmers. The trial court properly rejected this effort to make this end run around the statutory and contractual obligation or limitations on recovery, and we believe that this court should affirm. There are three grounds supporting Tennessee Farmers' position in this. The first ground, it deals with policy offsets. This case is not about priority of coverage, Your Honors. Instead, it's about the right of an uninsured motorist carrier by statute and policy provisions to claim an offset for and reduce its exposure by all amounts paid to the plaintiff's insureds under the liability coverage of the defendant tortfeasor's policy and from other sources. Tennessee's uninsured motorist statute provides less than broad coverage, as was held by the Court of Appeals in Irwin v. Rose, while the uninsured motorist statutes enabling an insured who is injured by an uninsured or underinsured motorist to obtain relief up to the extent of their own coverage, the statutes do not permit duplicate recovery. And we cite to the Court of Appeals in Clark v. Schoaf. That is exactly what the plaintiffs are trying to do here. Tennessee Code Annotated 56-7-1201D unambiguously allows an uninsured motorist carrier to limit its liability by offsetting all other insurance payments, bonds, and securities applicable to injury or death in question. That was held by the Tennessee Supreme Court in Poper v. Rawlins. The Supreme Court in Green v. Johnson held that the legislature's intent is to allow uninsured motorist carriers to limit their liability when an insured is able to collect monies elsewhere, no matter the source. The second point or reason showing that the trial court correctly granted Tennessee Farmers' motion for summary judgment deals with the uninsured motorist carrier limit of liability. The trial court correctly found that plaintiffs were precluded from further recovery from Tennessee Farmers under Tennessee Code Annotated 56-7-1201 B3D, as well as under the limit of liability clause of the policy, which provides, in no event shall the total amount of recovery from all policies and bonds, including any amount recovered under your uninsured motorist coverage, exceed the limits of your uninsured motorist coverage. The trial court observed that Tennessee Code Annotated 56-7-1201 permits policies to include such limitations and offsets which are designed to avoid duplication of coverage. And the third and final reason that we believe that the trial court was correct in its ruling granting Tennessee Farmers' motion for summary judgment deals with the definition of an uninsured motorist vehicle, or uninsured motor vehicle. As Tennessee Farmers asserted in its motion for summary judgment, the Oliver vehicle did not meet the definition of an uninsured motorist vehicle defined by statute and policy. The uninsured motorist statutes are designed to provide protection of persons insured under the policy who are legally entitled to recover compensatory damages from owners or operators of uninsured motor vehicles. Tennessee Code Annotated 56-7-1202A1 defines an uninsured motor vehicle in pertinent part as one for which the sum of the limits of liability available to the insured under all valid and collectible insurance policies applicable to the bodily injury is less than the applicable limits of the uninsured motorist coverage provided to the insured under the policy against which a claim is made. The Tennessee Farmers policy definition of the uninsured motor vehicle is the same. Here, the limits of liability to Hinds under all valid and collectible policies, $80,000 from Allstate and National Casualty, was greater than the applicable limit of uninsured motorist coverage under the policy against which the claim is made, the Teague policy. The Tennessee Farmers policy provides under what is covered, we will pay only compensatory damages which a covered person is legally entitled to recover from the owner or operator of an uninsured motor vehicle. Because the Oliver vehicle does not meet the definition of an uninsured motor vehicle, there is no uninsured motorist coverage under the Tennessee Farmers policy. To conclude, in this case, plaintiffs settled with defendant Oliver, receiving $30,000 each from Allstate under the liability coverage of the Oliver policy. Plaintiffs then voluntarily chose to settle with their own automobile insurance carrier, National Casualty, receiving $50,000 each, so the total received by each plaintiff was $80,000. The uninsured motorist coverage limit under the Teague policy, Tennessee Farmers Teague policy, is $50,000 per person. It's been the law in Tennessee for decades that insurance policy provisions limiting the liability of an uninsured motorist coverage are valid, and the uninsured motorist carrier is entitled to an offset and reduction for amounts paid to and received by the insured plaintiffs from all other sources. And after the payments by Allstate and National Casualty, the Oliver vehicle does not meet the statutory or insurance policy contract definition of an uninsured motor vehicle. We believe the trial court correctly applied the statutory limitation on recovery of uninsured motorist coverage. We believe the trial court correctly applied the policy limitation on recovery of uninsured motorist coverage. We believe the trial court also correctly found that Tennessee Farmers was thereby allowed to offset the $80,000 paid to each plaintiff against its $50,000 per person uninsured motorist coverage. And we believe the Oliver vehicle failed to meet the statutory and definition of an uninsured motor vehicle. And for these reasons, Tennessee Farmers can owe no additional sums to the plaintiffs. And accordingly, Tennessee Farmers requests the Court of Appeals affirm the summary judgment in its favor. And your honors, in light of Mr. Wolf's passing, if the court affirms the summary judgment, we would like to dismiss our claim for frivolous appeal. Thank you.
Thank you. Well, your case now has been submitted to this court for resolution. We want to let you know we appreciate your argument and presentation in this case, and you should be receiving our opinion and ruling within a reasonable period of time.
Thank you, sir.
Thank you. Mr.
Thank you,
Campbell.
Marsh.
It's a pleasure, Mr. Campbell,